The Constitutional Court has given Parliament 24 months to correct errors in the Divorce Act. The court ruled yesterday that parts of the Act are unconstitutional. Before the ruling, an individual married out of community of property without accrual couldn't claim, and I suppose still can't claim, from their spouse's estate when a divorce takes place. Now, Section 7, subsection 3 of the Act now allows the courts to divide the assets in a more fair and equitable way if that individual can show that they made a significant non-financial contribution to the marriage. The Commission for Gender Equality has welcomed the ruling. In fact, let's bring in Commission Acting CEO, Dr. Dennis Matotoka, joins us via our video link this morning. Dennis, it's great to see you. Thanks very much indeed for coming on. And I do think that maybe my introduction was a bit complicated. Can you break it down for us? What did the court have to say about the Divorce Act in its current form?
I think maybe let me start it firstly from an international perspective. When you look at the number of international instruments that South Africa is aligned to, it requires state parties like South Africa to put in place protective measures, especially where there's unequal balance of bargaining power between married parties in a marriage. Now, what it requires is that when you look at the antenuptial contract, the state must look at, is there an equal bargaining power between the parties? And if there is, presumably because of a prejudiced background, be it women, the state is obliged, therefore, to now determine what is it that we can put forward to protect the vulnerables in society. Now, coming back to the issue at hand and hope, we note that we have the Matrimonial Property Act that was legislated in 1984. What it requires is that the parties that enter into a matrimonial property system without out of community of property, it must be done without an accrual system. What it essentially means is that you agree that you shall share the accrued assets between the parties, especially if one party has not had a accrued property to the equivalent value of the other party. So then you'll have to share the difference and so forth, to the equivalent of being half of the other party. So that was the Matrimonial Property Act in 1984. Now, the challenge is the matrimonial property system allowed parties to enter into an out-of-community of property for profit and loss and without an accrual system. What it fails to recognize is that there are direct and indirect financial contribution made by either party. But in this instance, we're talking about women. And we know that historically, women have been prejudiced and they have not had a bigger bargaining power when it comes to marriage. They enter marriages being poor. At some times, it's because of the background that they're coming from. Now, when they enter into antenuptial contract without an accrual system, what we know and understand is that there are non-financial responsibilities that they play. That includes your child care responsibilities, your household responsibilities, and the maintenance of the other spouse, who generally are men in this instance, the maintenance and the growth of that estate. Now, what happens is, upon dissolution of the marriage by divorce, you realize that all that non-financial contribution that was made by a female or a wife in this instance is not finding any recognition. And what it does is that then the woman in this instance walk away from the marriage with nothing. And our argument as a commission before this court was that both non-financial and financial contribution need to be considered and put in the same weight. Because we know that ultimately they contribute towards the growth of the other spouse. And it's very much important that they find protection as well.
Yeah, absolutely. So I mean, from what you're saying, it's about time that we've had this ruling from the Constitutional Court, right? But what happens to people who have been impacted by this Divorce Act before this Constitutional Court ruling?
So what we need to understand is that the constitutional invalidity is suspended, and Parliament is given 24 months to really come up with a legislation that will address the constitutional defect that has been pointed out. And part of the ruling of the court was that the text in the Matrimonial Property Act, specifically the one that makes reference to before the commencement of the Act, it's now struck out. it now says parties within a marriage who entered into an antinuptial contract, which means, therefore, from the date of the ruling going forward, the parties are now covered.
Yeah.
Unfortunately, we cannot say by those that in previous years are correct.
That's a shame, and I'm sure people who are listening out for this interview will feel some sense of regret over that. But as you say, it's a good thing. I mean, does this essentially mean that the Matrimonial Property Act in itself is almost null and void, or is that overstating it?
It's overstating. It's only part of the section that needs to be amended. But I think the matrimonial system is still very much important. The in and out of community property systems, we must still have that.
Of course. I mean, even today, we have this conversation, right? And it is something that does impact women much more across the board. This issue that, you enter into a marriage, perhaps you have a full-time job, perhaps you don't. Perhaps your full-time job is taking care of your home. But either way, there is a lot of unpaid work that women in our country, and I suppose this goes for women anywhere, that they are responsible for and that there is no compensation for.
Absolutely. And we must remember, I think one of the arguments in the court was that parties now, after 1984, they had a choice. I mean, you had a choice to enter into an antinuptial contract with an accrual system. Without an accrual system, you had a choice. But we must remember that the choice, especially when it comes to matrimonial agreements, is unlike a commercial agreement. It's informed by a lot of social dynamics from a cultural and a religious background and all of that. So all those dynamics come into play, and we must recognize that. And as the CGE, we are saying, to failure to recognize those social dynamics, the cultural and the religious factors that come into play when parties enter into a marriage, is to avoid or fail to recognize the prejudice that women, particularly in the country, have faced historically regarding their exclusion from participating in the economy and the continued violence that they experience. We have said in the judgment, one of the issues is that you find that a partner who does not have a bargaining power and knowing very well that they are not going to get anything out of the marriage, at times they are forced to stay in that marriage for the longest time. Yeah. And this is where now intimate partner violence even happens. And we are saying you need to provide, as the country, protective measures to cater for such instances. And that's the basis why, as the CGE, we welcome this judgment. Yeah,
absolutely. Such an incredibly important point. And it's an empowering judgment for women, right? And now the answer, or rather the thing that we need to focus on is education. Now we need to get that message out, that this is what the Constitution has said about what your rights actually are.
Absolutely. As the CGE, for example, we have a public education department, and this will form part of the programs that we'll be taking out to communities across the country to sensitize them about the changes that have been made by the Constitutional Court. But in addition to that, we know in the next 24 months, we need to come up with that legislation. We'll have to play a critical role to make sure that the constitutional defect that has been identified is really addressed. And we have said in the judgment, we need a framework that will guide the judges when they exercise that discretion. And we have said also in the judgment that we would want the distribution of the accrued estates to commence right from the beginning. And that is an issue that we are going to ventilate with Parliament when they attend to the legislation, so that we can have a just and equitable distribution of assets upon dissolve of a marriage, be it by death or by divorce.
Yeah, so your input as the Commissioner of Gender Equality continues as Parliament now deals with these errors in the Divorce Act. As you said, the Constitutional Court giving the House 24 months to correct these errors. Dr. Dennis Matotoka, let me thank you for your time this morning, the Acting CEO of the Commission for Gender Equality.